along with Snickers,
Yeah.
yeah.
I don't want to turn into Betty White up here.
Good evening. It is 6 p.m. and this is our first planning board meeting of the year. The board will elect one of its members as chairperson and another of its members as vice chairperson. First, I'll take the roll. Ms. Shaw?
Here.
Mr. Galloway? Mr. Galloway?
Galloway?
I can't hear.
Mr. Jorzak?
Here.
Mr. Scudero?
Here.
Mr. Railsback?
Here.
Mr. Dumoulin?
Here.
Chairman Thomas?
Here.
Elections for chairman?
I'd like to make a motion that we keep both the chairperson, and vice chairman as
Second.
chairperson and vice chair.
I'll second that.
Okay, vice chair?
I'll make the same motion that we keep the vice chair.
Second.
Okay. Okay, I will call the vote. Ms. Shaw?
Yes.
Mr. Galloway?
Yes.
Mr. Jorzak?
Yes.
Mr. Scudero?
Yes.
Mr. Railsback?
Yes.
Mr. Dumoulin?
Yes.
Chairman Thomas?
Yes.
Administrative items?
Okay, thank you very much. Thank you for the board for your trust and try and do a good job. Okay, we've had the elections. We're going to have to adopt the planning board rules and procedures.
So move.
We have a motion
Second.
and a second. Marcel, I think we can do this by a verbal.
Yes.
Okay, all in favor, aye.
Aye.
All opposed by the same sign? All right, then we'll move on to the adoption of our planning board calendar.
So move.
Second.
I have a nomination, motion and a second. All approve? Aye.
Aye.
All disapprove? All right, and then we'll go to the site plan review committee calendar.
So move.
Second.
Motion and a second. All in favor?
Aye.
All opposed? Okay. Now we'll have the invocation. Our Heavenly Father, thank you for the opportunity to come together as a community to look and see what we need to do for our community, for the betterment of all the people that live in our community. Thank you for those who protect us, guide us, help us, and watch over us. Be with our military, protect them. Be with our police department and look after them. Thank you for the bounty that you have provided Ormond Beach with, and help us to make the decisions that are best for all of our community. In your name we pray, amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Please note that the board will not take up any new item after the hour of 10 o'clock. And is that okay with the board, or since we're starting at 6, you want it for 9? What do you, we have a hard time, close time at 10 o'clock that we have to be out of here. So with your approval, we'll just kind of put at 10 o'clock that we will not take up any new item after 9 o'clock.
Works for me.
Is that okay?
Yes.
All right. Randy, do we have to vote on that?
No, sir.
Okay, thank you. Okay, we'll do the approval of the minutes.
Move approval.
Second.
I have a motion and a second. All in favor?
Aye.
All opposed? Okay. Then we'll go to the planning director's report.
Steven Spraker, Planning Director. Just wanted to remind the board that there is a neighborhood meeting on January 18th at the Hampton Inn for the Tattersall project. It will come back before the board. It has its approved planned residential development, and they're doing the construction plans right now. So just a reminder of that neighborhood meeting next week. Available for any questions.
Okay, anybody have any questions of Stephen?
Thank you.
Okay. All right, now we'll go to the public hearing, PP 2023-084, Fountain View Phase 1 subdivision preliminary plot. Stephen?
Thank you. If we can go to slide 3, please. Good evening, Steven Spraker, Planning Director with the City of Ormond Beach. This is a request for a subdivision. It's Fountain View Phase 1B. It's a preliminary plat. There's a total of 137 lots on approximately 78 acres. It is part of the planned development of Plantation Oaks. With that, all streets are private. It does abut Interstate I-95. The connection to this subdivision would be Fountain View Phase 1, and then there are recreation amenities including dog walks, cabana, pickleball courts. Next slide, please. This slide shows the overall Plantation Oaks planned residential development. It's located on the top of the screen, again, next to I-95. The pink color is Fountain View Phase 1A, which the project will connect to. Next slide, please. So for the development of the subdivision, there's a 3-step process. The first is the zoning, which they had approved. The latest amendment was in 2022. The next step is the preliminary plat, where they do the detailed construction plans, which was in your packet tonight. And then after that, they do a final plat, which is a legal document to subdivide the land either after construction or posting a performance bond. Next slide, please. The Site Plan Review Committee has reviewed this application and recommends approval. The applicant is here to address the board if there are any questions.
Does anybody have any questions of Stephen at this time? Yes, Angie.
Did they take care of the Site Plan Review Committee items that were in this packet?
They're in process. You're talking about the interconnection, the emergency access. Second is probably the most important. They're working on it. If we can go back to slide 4. So there are other connections with Fountain View Phase C, which is under site plan review. So there's a mechanism to get that emergency access easement. We're just working it out. We don't believe it's a comment that would stop the construction.
Okay. One more question.
Yes, ma'am.
I noticed that there are some billboard locations on here. Were those existing already?
Correct. They are existing and they're allowed to stay.
Okay.
Yes, ma'am.
Mike?
Stephen, if you can just clarify, because I know we have a lot of new folks here tonight. I believe both the zoning and the density for this has already been approved, correct?
Correct. So if you remember that 3-step process, they've already gone through their zoning aspect. And the purpose of the preliminary plat is to show that it's consistent with the zoning entitlements, which it is.
So our only role tonight would be to say if we didn't like where one lot sat in relation to a buffer or a retention pond or something, but the overall magnitude of this particular project was decided some time ago.
Correct. It's more of a technical review that basically shows consistent with the approved planned residential development.
Anybody?
Thank you.
Okay. No more questions? The applicant?
Good evening, Parker Minchenberg, 1729 Richwood Avenue. Engineer and developer on the project, and we basically are in with preliminary plat and construction plans. We have to demonstrate to the staff we meet the land development code, which we have. And to your point, we've kind of worked out the emergency access, so I don't think that's an issue. And if I can answer any other questions, we're anxious to get started.
Anybody have any questions?
Parker, how long do you think it'll be before you're going to complete this phase?
It'll probably take about 10 months to construct.
Okay. All right, thank you.
Thank you.
All right, and we'll bring it up to the board for discussion, or chair, if there's no discussion, chair will entertain a motion. I'm sorry, is there anybody in the audience who would like to address this issue? I didn't see any cards, so that's, I guess not. So.
Okay. If that's the case, then, Mr. Chairman, I'll move approval of this item. Sorry.
Up at the top.
Yeah. Phase 1B, preliminary plat. I won't say the long project number, but I think we know what it is.
Second.
I have a motion, a second. Is there any discussion? Marcella, would you call the vote, please?
Ms. Shaw?
Yes.
Mr. Galloway?
Yes.
Mr. Jorzak?
Yes.
Mr. Scudero?
Yes.
Mr. Railsback?
Yes.
Mr. Demulin?
Yes.
Chairman Thomas?
Yes. Okay, then we'll move along to the PP 2023-074 Bradford Park subdivision preliminary plat. Stephen?
Good evening again, Stephen Spraker, Planning Director. This again is a request for a preliminary plat. There are proposed 180 townhome lots on approximately 25 acres. This project had to do some preliminary zoning actions. They took land which was zoned for commercial and they made it residential. So they went from low intensity commercial land use to medium density residential, and they also changed the zoning to residential. The property was annexed into the city in 2023 on August 15th, and then they did some right-of-way vacations, which essentially cleaned up some of the National Gardens plats from 1926. Next slide, please. The land use on the property is medium density residential, and the zoning is R4. The R4 allows townhomes as a conditional use, which was reviewed by the Site Plan Review Committee. Next slide, please. The project has a gross density of 7.22 units per acre. It meets the townhouse conditional use criteria. There was a traffic study that was required and that was completed. That was reviewed by an independent consultant hired by the city. This project is going to be a sister project to Bradford Lakes, which is on top of the screen. That is part of Plantation Oaks Phase 4. There are 80 lots there. They will share a lift station. This project will construct Pennsylvania Avenue, which is on the top. So Pennsylvania Avenue will provide access to both Bradford Park and Bradford Lakes, and they'll share recreational amenities. So it's a good dual use for both the subdivisions. Next slide, please. Again, there's a three-step process for a subdivision. In this case, they're going through the R4 zoning district, which allows the townhomes. Their application is for a preliminary plat, which is the construction drawings, and then the final plat will be before both the Planning Board and Commission once they're at that stage, if approved tonight. Next slide, please. The Site Plan Review Committee has reviewed it. There are some minor comments that are outstanding. Staff is recommending approval. Again, the applicant is here to address the board if there are any questions.
Yes.
Greenery and landscaping, I don't see a lot on here. Is there a requirement?
Absolutely. They're saving 15% of the site as required by our Land Development Code. If we can go back to slide 9. So against I-95, they're providing a greenbelt buffer, which is shown on the top left of that corner. There's a natural preservation below on the very bottom right of the screen. There's landscape buffers along Plantation Oaks Boulevard. There are internal landscape buffers, so they've met the landscape requirements of our land development code.
Okay. Just didn't look like a lot on the drawings.
It's at a scale that's hard to, so that's why we try to do some of our coloring. So we tried to show where the green areas are. And there's a landscape buffer along Pennsylvania. So the boundaries have those landscape requirements. They've saved 2 historic trees, so they've worked around the historic trees that were on the property. So they've gone through an extensive landscape review.
Okay, and one more question.
Yes?
The rear and side elevations, I noticed the windows are super small. Does the city have requirements with the way the exterior is supposed to look?
We do. We have the neo-eclectic, and basically we've asked them to increase beyond what our code requires on Plantation Oaks Boulevard, the visible side of the project. They do meet the neo-eclectic architectural style. If there's something you want to discuss, you can ask. We're really more in a technical review than a discretionary review, but you could always ask.
Okay, thank you.
Yes, Mayor.
Okay, this is going to sound a little offbeat here, Steve, but is there any possible way when they do these ecological studies, and I'll tell you in a minute where I'm going with this, that a planning board member can be present when they conduct those studies, or when they go out into the field and look at that plat of land?
So
That's number one.
right. So typically we don't have planning board members do that. I'll defer to the city attorney's office, but typically they're technical reviews. They're reviewed by St. John's. They're reviewed by the city. If there's a specific question, the environmental designer is here today. So.
Well, as I read all these packets throughout this year, and it's only been a year that I've been on this board, I'm starting to notice a common denominator. And what that is all these reports that come back, both the traffic study and the ecological studies, saying there's no impact to the areas at all. They don't find any in the flora and the fauna, any endangered features there. They don't find an abundant amount of wetlands. And what was very disturbing when we got to the gopher turtle section was it said, no, however, due to the dense cover, it couldn't be truly determined as far as where there were any endangered species. It couldn't be truly determined. However, within 90 days of construction, the ecological consulting company recommends 100% survey. That means the construction people are going to have to go into the land and look for this stuff, look for the endangered species.
That's a state requirement for the gopher tortoises. So, and again, I'd probably defer more to the environmental expert. For example, the traffic study, that's prepared by a professional traffic engineer. That's reviewed by a professional traffic engineer that the city hires. An independent expert doesn't have any skin in the game for both the city or the applicant. So there are technical standards that they prepare these reports to. And again, the applicant has a design team here if you'd like to talk to them about it.
Okay, I would like maybe do a sidebar with them. So,
Mr. Chairman, if I can kind of refocus you too. So your task this evening is to determine whether the preliminary plat is consistent with the prior development order that was approved by the commission. The details of the development will be ferreted out through the various technical review components. I mean, you can ask some questions about it, but it kind of falls outside the parameters of your task this evening.
Yes, sir. Okay, anybody else have any questions?
Just a point of interest, what is the target price range for these townhomes when they're built?
Yeah, definitely a question for the applicant. I'll let them address that.
Okay. Any other questions of Stephen? Okay.
Thank you.
All right, thank you. Yes, sir. Step right up.
For the record, my name is Glenn Storch, 420 South Nova, and I'm representing the applicant in this case. So let's start with a couple of questions. The gopher tortoises, near and dear to my heart. The bottom line is the reason why all gopher tortoise nests are not determined at this point is because they move. And so what the state requires, as well as what we require, is that we wait until we're ready to proceed to make sure we get every single gopher tortoise in place in there. And that's what's required then to relocate those gopher tortoises at that time. So
Who oversees that, though?
I beg your pardon?
Who oversees that?
Where's
the accountability?
The state, the city, everyone. I mean, this is really important. So yes, we all oversee it to make sure it's done properly. We have experts that do go in there and look and make that determination. And then of course, when you find it, there's a cost to removing the nest, removing the gopher tortoise to make sure they're safely relocated. But that's what happens. There's a mitigation process to make sure that no gopher tortoise is harmed whatsoever. And I thought it was interesting, the question of whether you could actually be out there with the applicant looking at this. I'm sure that the city attorney would say, does that create an issue when you're the judge and out there as a witness? So you got to be careful about that, I'm sure. But we have nothing to hide. If people want to go out with us, we have no problem with that at all.
Thank you.
Okay. Is that it? Any other questions? I mean, as you know, this is a different setup. If this was a zoning issue, we could be looking at zoning issues, but right now we're looking at plat. And under the state law, if we have met all the criteria, if we have met the criteria for the comprehensive plan, if we've met the criteria for the zoning, which we have, if we've met the criteria for the land development code, which your staff just testified that we did, at that point, there's a ministerial act, and we are entitled to a plat at that point. So that's what we're looking at now. If there's anything we've done that is not consistent with the land development code, we can talk about it, but I think we've done everything required.
Well, I realize that this is a side issue and it's not particularly relevant to what we're talking about.
I don't mind.
But with the emphasis that we have on the mix of our housing in the community,
yeah,
and what borders on affordable housing and what borders on medium income housing and how many units we're developing in these developments as they come through the system, get some kind of an idea as to what that mix is from a price standpoint.
We have an idea
as to affordability with whatever's going on in the real estate industry.
I think he's trying to get an answer for you.
So right now, of course, there's obviously it's depending on what actually cost, but right now we're estimating the high 200s.
The high 200s.
Yes.
Do you know where the affordable housing limit ends?
It depends. There's different affordable housing criteria. If you're looking at some of them, you're looking at 30% of your income being affordable housing. And so if you're below the median scale of housing, and that could be, your housing could be literally less than $45,000 for a home. You can't build a home for $45,000, obviously. Some of the things you need to do in order to make more affordable housing is to look at the idea of yes, some smaller housing, because that's the smaller the housing, the less it cost. There was a time when I was growing up when we had 1,000 square foot homes and three kids in those homes, and everyone was just fine. We've gotten away from that. So there may be a time at some point when we start looking at smaller homes to make it more affordable. At the same time, you've got to do things that will also create affordability in other manner. So if you can create affordability by having homes located in areas where it's closer to shopping, closer to jobs, that means you're not paying all that money for the cost of transportation. So there are things you can do to look at this, where you're looking at mixed uses that will in fact increase affordability. But it's a difficult issue, just because of the actual cost.
No, I understand that, and all I was trying to do was get some perspective as to the mix of housing that is being developed in our area.
Yeah.
And how that relates to the needs of the people in the community and the diversity of.
Yeah, interestingly, townhouse units are probably among the most affordable of the product?
I
that can be done?
would assume so, other than single and double wides, but,
Right.
yeah, but that was my interest, basically, was to try to get a feel for what that is, and it would apply to virtually all the developments that are
Yes.
going on.
Yeah, and I got to tell you, I totally agree with this. You know, as a father of 30-somethings, finding housing for the kids of the next generation, not easy right now.
Thank you.
Thank you.
Anybody else have any questions? Okay. All right. Then is there anybody in the audience that, I don't have any cards, so I will bring it up to the board. Anybody have any discussion on this? Any thoughts? Then the chair will entertain a motion.
I'll make a motion to approve project number PP 23000074.
Second.
I have a motion and a second. Marcella, would you call the vote, please?
Yes, Mr. Scudero?
Yes.
Mr. Railsback?
Yes.
Mr. Dumoulin?
Yes.
Mr. Jorzak?
Yes.
Mr. Galloway?
Yes.
Ms. Shaw?
Yes.
Chairman Thomas?
Yes. Okay, thank you. I was remiss in two items. One, would you please turn off any cell phones or mute them if you have them? And number two, to remind anybody that wishes to speak tonight to fill out a card. Some people have sent up some, but in case you weren't, this is your first time, you must sign up a card before you can speak. Okay, so now we will move to the 2MA 2023-054 Tomoka Reserve, 20 Tomoka Oaks Boulevard.
Good evening again, Steven Spraker, Planning Director. Next slide, please.
Mr. Chairman,
Oh, yes, sir.
can we go through some preliminary matters before we get to the
Absolutely.
order? So, so this is similar to what we went through on the prior matters that this board considered for this property. So we don't go through them in every instance, but on matters of significant public importance, it's always helpful to go through a summary of the points that will guide you in your decision this evening. So the application before you this evening is an application to rezone property at 20 Tomoka Oaks Boulevard, the former golf course property as it's commonly referred to. The prior applications you had before the development application under the existing PRD zoning. So the sole question for the body this evening is whether the property should be rezoned on the standards for the rezoning of the property, and not details of the development of the property. You know, this is probably the fourth or the fifth hearing that we've had on this, so the underlying facts haven't changed. They are pretty much as they've always been. You will recall that at the prior meetings, the developers' representatives informed the board that it would pursue an R2 rezoning application in the event that its application for development under the PRD zoning was not accepted. That matter was remanded back to the planning board. As you may recall, it was not denied, but be it as it may, the applicant has decided to move forward with the rezoning application, and that's what you have before you this evening. So at the prior public hearings, you may recall that the developers team discussed some matters related to the R2 zoning. Try to keep those separated, but it's difficult to do that. So the information from the prior public hearings have been included in your packet for whatever relevance it may have regarding the question of rezoning, not the development components of the land, but for the rezoning purposes of the rezoning application. You can give it whatever weight you wish to give as relates to the question of rezoning. So this too is a quasi-judicial proceeding. Formal rules of court don't apply. There are rules that do apply. The decision of the board is advisory to the City Commission. The burden of proof initially lies with the applicant to demonstrate that the application for rezoning is consistent with the comp plan and other ordinances and laws, and if so met, then the burden shifts to those in opposition to show by competent substantial evidence that the rezoning should not be applied. The city's code allows, has a mechanism to allow parties who may have an affected, substantially affected interest to intervene as a formal party in a proceeding. The Tomoka Oaks HOA, as you may recall, in the prior proceedings on the development application, requested party intervener status. Consent was given. That was accepted by stipulation of this board. The HOA has filed a request to be treated as a party intervener in this rezoning request. It was timely filed. I received a letter from the applicant's attorney 4 o'clock this afternoon objecting to party intervener status for the HOA. We'll talk a little bit more about that this evening. The provision in the city's code of ordinances does not specify, well, I think it contemplates that the party intervener status be afforded during the final hearing at the commission level, but it doesn't specifically state that. So in the prior matters, this board heard the request, granted the party intervener status, and then the commission did the same at that next level. I have not had an opportunity to speak with the attorneys for the applicant before the meeting. I did have an opportunity to speak to the attorney for the HOA, and he tells me that party intervener status before this body, since it's a recommendation only, is not as important as it is before the city commission. So he may not necessarily request that for this proceeding, but I will defer to Mr. Baer if you wish to inquire about that further. If they do wish to move forward with their request for party intervener status, then they will have to show to this board how their interests are substantially affected in this rezoning matter. You get to make the decision. You get to weigh the balance of that evidence. Now, the attorney for the applicant has requested 20 minutes to respond to that. I think that's very exorbitant, frankly. But you have some discretion in terms of how you want to treat that. Your rules don't provide for how you're going to handle those matters, so it's within your discretion as long as it's fairly administered. So your rules do provide for an order of business, and in the order of presentation, it would call for the planning director to present the application to the board, followed by the applicant is afforded an opportunity. 20 minutes are allocated. We do not have a set time period for party interveners, but the board decided in the prior proceedings that 20 minutes was fair. If the HOA does not pursue its party intervener status this evening, then the normal rule is that residents get 3 minutes. If a if a group of people is being represented by an attorney or by a spokesperson, you can allocate additional time to them, whatever you feel is appropriate under the circumstances. So you have a lot of discretion in terms of how you want to treat that procedural issue. Witnesses do not need to be sworn. They can be sworn if you so choose. The judges certainly find it helpful if they are in these proceedings. You can, if you choose to do so, you can swear them individually or you can do them en masse like you had done before. The members of the public that wish to speak should fill out a card, and I think you have some of those as well. And then as you open the proceedings for the presentation of the applications, I think your first inquiry should be of the Tomoka Oaks HOA as to whether or not they're going to request party intervener status in this proceeding this evening. If they are, then we can handle that as a procedural matter. If they're not, then you can go directly to the planning director. And then from the planning director, it would be the applicant's presentation, 20 minutes total. If there's a party intervener, 20 minutes. If not, then you just skip straight to the resident presentation, 3 minutes or as much time as you decide to allocate. And then the applicant, the last time we gave about 10 minutes for rebuttal. And then that's followed by questions by the board and deliberation and decisions by the board. And during the deliberation and decision by the board, period, typically there's no more questions asked. Procedural matters such as points of order, that's a parliamentary procedure. That's for the board. It's not for members of the audience. Okay? So just so that we're clear on that point. With that, Mr. Chairman, I will turn it over to you. If you have any questions for me, I will be happy to answer them. Otherwise, you can just proceed.
Does anybody have any questions for Randy? Okay, then if the board will indulge me for a minute, and if I say something that you do not agree with, please let me know and we will discuss it. This is our 4th time dealing with this piece of property. We have done this 3 times, and in all 3 times we have had a certain procedure. And if I have my way, we're going to stick by those procedures that we have done in the previous 3 meetings. Whether the HOA wants to have intervention time, they're going to have the opportunity to have that if they change their mind during the course of this evening, so that we're going to leave it just like it was the last time. We're going to swear in everybody just like we did last time, and everybody will be held to 20 minutes, period. 20 minutes, period. If you want to talk about the weather, go ahead. But at the end of 20 minutes, the time limit will have expired. So with that, I think that's just like we did it the last time. I see no reason whatsoever of changing the rules tonight. And I will be quite honest with you, I do not like getting an email at 7:18 this morning with the applicant sending out a letter with all kind of objections and conditions and everything else. And I look at that as either being totally unprepared or intimidation. And if you're going to try and intimidate me, you might as well hit me upside the head with a 2x4, because you're going to get my attention. And I do not appreciate being notified at the last minute. I do not think it's fair to all these people here. I do not think it's fair to my board. I don't think it's fair to anybody. So therefore, this meeting will be held like the previous 3 meetings. And if it gets unruly, we'll take a 30-minute break. So from there on, we will continue now. Is that okay with my board?
Can I make one additional suggestion? I agree with everything you said, by the way, Mr. Chairman. At the very first meeting, I threw out a suggestion that we hold a time certain vote, given that whichever church we were in had a closing time. Given that this is now our 4th discussion on this same piece of property, I'm going to again ask that we hold a time certain vote tonight on this issue so that everyone can leave here knowing the outcome.
And if the board is okay with that, and if the board would prefer to set a time,
I would just say 9:55 at the latest. If we're out by 10, as long as that's good back there, no later than 9:55.
We have a hard time at 10 o'clock that we have to exit the building. So 10 o'clock and it's over.
Mr. Chairman?
Yes.
So, and that's fine. I think the applicant is looking for an expeditious decision on this application as well. So this is a new application, and you have to receive evidence as you did any others. The decision have to be based on the competent substantial evidence standard the way it was previously as well. So to the extent that you feel that you've got enough evidence to do that, then that's all well and good, but I just wanted to restate that for the record.
So if it has to be continued, it has to be continued.
Well, this is a rezoning application. This is not an application for development order. So if there's a need, we can address that at the time.
Right.
And we can take that up and discuss it for what it is. But, you know, the facts are unchanged. You know the facts. This is just a different application. You know, the review is a little bit different, but it's a little bit of the same, right? So the real issue is you can't really talk about the elephant in the room, but everybody knows it's here, right?
Yes, sir.
So it's
Okay.
back to you.
Mr. Chairman,
Yes.
I just want to, I've lived in this community for 41 years, and I consider myself as a developer. But lately, we've been put under the pressure by developers, mainly from out of town, and people representing developers. And it's in a way like example what happened at 40 in Timber Creek, that there's a thread of threat or bullying that I want to put my friends on notice. That is not the way to come to this group, and I'm a volunteer, and I'm in Tallahassee working on behalf of a project, doing hearings, and I too receive 1, 2, 3, 4, 5, 6 letters that I don't even have an opportunity to read it because I'm working on behalf of something, and then the law says that if I'm driving back, I can't read a letter. And I want to tell my friends in the industry, in the football days, when we planned to win a national championship, we prepared prior to the day before the kickoff. We started preparing in August for a national championship game that was held January 1. It is an insult, and I wish the gentleman who wrote this letter would please stand so I can see him and I know who wrote me the letter. Thank you very much. I am not going to be put up or serve on this board and be bullied. And we were in a meeting in Tallahassee, and developers are starting to try to bully communities and individuals on the Live Local Act to do things that we do not need to have in our community. And I don't know which way I'm going to vote because I haven't had time to read this, but I'm going to tell you right now, through those people representing projects and friends of mine, stop bullying us to approve a project. Thank you.
Thank you. Okay. All right, so Stephen?
Good evening again, Stephen Spraker, Planning Director. So this is a request for a zoning map amendment to go from planned residential development to the R2 zoning district. On the map to the left is the zoning, so it's zoned as low-density residential. And on the map to the right is existing zoning of planned residential development. Next slide, please. So the zoning map area, the subject property, it was platted in 1961, became a golf course. There were residential lots that were developed around the golf course, creating a symbiotic connection between the golf course land and the residential lots. In 2006, there was a zoning change from R2, single-family low-density residential, to the planned residential development. And that development order had 119 multifamily units, 3 single-family homes, and the preservation of a golf course. In 2014, that development order, including the conditions of preservation of the golf course, expired. And in 2021, the applicant, Triumph Oaks of Ormond Beach 1, purchased a property which was the former golf course land area. Last year, there were 3 planning board meetings and a city commission meeting. As the city attorney said, the minutes are in your packet. The commission remanded the application back to the planning board to review concerns including density, traffic, compatibility with the zoning neighborhoods, lot size, natural area. On November 21st of last year, the applicant withdrew the planned residential development, the issuance of the development order, and sought a zoning map to the R2 single-family zoning district. Next slide, please. So what is a zoning map amendment? This is different than what you reviewed in your last applications. So there are a number of different zoning districts, and each of those zoning districts contain uses. Some are permitted, some are conditional, some are special exception, and they contain the dimensional standards of that zoning district. One of the issues with the planned residential development, it's a site-specific development order. And I think the applicant is saying there are no entitlements within that development order, which is why we're seeking to go to the R2 zoning district. So your application tonight doesn't have any traffic studies, any environmental studies, any landscape. Those are not what you're reviewing tonight. You're reviewing the appropriateness of the zoning district. We've been asked, how many lots can you get with the R2? Quite honestly, we don't know until we see a site plan that's been engineered, it's taken into tree preservation, natural areas. So we're not gonna be able to answer, what is the number of lots that they can develop? And I've seen a lot of numbers floating around. So if approved, the R2 zoning district, similar to the two applications that you had earlier tonight, they would be reviewed by the Site Plan Review Committee. They would perform a preliminary plat. That is the detailed construction plans. That's what you saw in the first two applications. It's acted upon the planning board and then the city commission. Once either construction starts or a bond is posted, the final plat, the legal document to subdivide the land, would go back to the planning board and then to the commission. Next slide, please. So section 2-2 of the Land Development Code provides the compatible zoning districts for the low density residential. So there are 5 zoning districts by the Land Development Code that are deemed compatible. The applicant is requesting the R2. Basically in the application, and I think in discussions, the zoning of this former golf course area was R2 prior to 2006. We found a zoning map from 1956 that showed it was R2. The surrounding subdivision has an R2 single-family low-density zoning, and the R2 is consistent with the low-density residential use. The review of the planning board tonight is to figure out which zoning district they believe is the most appropriate. You could have multiple zoning districts which are consistent. It's kind of like one of those math problems you had in high school of what's the best answer. So that is the role tonight, and you've got correspondence from residents, you got correspondence from the HOA. I think there were 2 certified planners, and you have the applicant, both their application and the letter that was received last night. Next slide, please. So planning staff review, and just not me, basically we have discussions through all our staff, and these were the final points of analysis that we did. Throughout the issuance of the development order, there's been a recognition that the Tomoka Reserve property is unique and unusual. There are not many land areas that are entirely surrounded by, I believe, 178 single-family homes. It is truly a one-of-a-kind. I believe Board Member Scudero said the hole in the donut was an analogy that I think has been used. The goal of the zoning map amendment, again, is to assign the most appropriate zoning based on the unique and special characteristics. Within the plan development zoning, staff believes that would provide a better overall subdivision standards, recreation, open space, natural preservation, and the opportunity for negotiation. One of the things the commission acknowledged at the planned residential development issuance of the development order was that they believed the appropriate zoning was the planned residential development, based on the uniqueness, the one-of-a-kind property, the potential impacts to those existing properties that had developed with the expectation of some type of buffer natural area next to it. And then development of the golf course under the planned residential development, in staff's opinion, is better suited to accomplish the goals and objectives of the Land Development Code and Comprehensive Plan. Next slide, please. Oh, I think forward, so, yep, perfect. It is recommendation that the planning board deny the applicant's request to rezone to planned residential development to the R2 and maintain the existing planned residential development. Staff is available for any questions.
Anybody have any questions of Stephen? Thank you, sir.
Thank you.
Okay, now we'll hear from the applicant.
Mr. Chairman, members of the board, my name is Carl Sanders with the law firm of KJS Law, PA, 1102 A1A North in Ponte Vedra Beach, Florida. My comments will not be long, and they certainly will not take 20 minutes. First off, as a preliminary matter, I would like to, if I may, Mr. Chairman, address the procedural issues, and thank you for agreeing to use the same procedures in this proceeding as you did the last 3 hearings you had. Perhaps my correspondence to Mr. Hayes on that issue was misunderstood. My communication was designed to ensure that Mr. Baer had as much time as this board deemed necessary or as he deemed necessary to provide a meaningful opportunity to present his client's objections and concerns to you. And that's it. I'm not here to talk about legal standing. This is not a court of law. As to the other correspondence that you're referring to with my the discussion of legal issues, which is not for discussion before this board. Again, my apologies if you were offended by that. The letter was not addressed to you. It was not written for you. The letter was provided to you to ensure it's part of a record of these proceedings, that's all. Those issues are purely legal issues, and as your city attorney knows, those types of issues have to be raised and be part of the record in order to be part of any subsequent judicial proceeding. And we determined that the most efficient way to communicate those objections would be do so in writing and have that put in the record instead of taking the time up of this board volunteers to listen to legal arguments, which is really not an appropriate forum to make those arguments. So with that being said, I will proceed with my comments this evening. Number one, the hearing before you tonight, as your legal counsel correctly advised you, is on a different application. We are not here to rehash the old application. That one's gone. What you have tonight is a zoning map amendment application. And it is a conventional rezoning application. What we are asking the city to do is to amend the label that is on your official zoning map atlas from PRD, Planned Residential Development, and reassign the historical zoning district label that has always been assigned to this piece of property, and that is R2. That's all we're asking for. So to the extent that there are any questions or concerns of any kind about any proposed development on this piece of property, we're not here to talk about that tonight. That was the purpose of the prior hearings which was a PRD development order, where it was an attempt to negotiate an agreement that was acceptable to both the city and to the neighbors. That failed, so we moved forward as we were entitled to. And we are asking that this label on your official zoning map be changed to reflect a zoning district that actually provides the property owners with entitlements to use their property. And that's the fundamental problem with the position that we're in right now. Through no fault of this board or anybody else. The reason for that is, the reason we have no zoning entitlements for the property, i.e., there is nothing that we can do with our property today. Staff has indicated this on numerous occasions in writing and verbally. And Mr. Spraker's correct in that respect. And here's why. Because the fundamental difference between a PRD zoning district and a conventional district, in this case would be conventional residential zoning districts for low density residential, or R1, R2, R2.5, R3. The difference between those two is with a conventional zoning district, the zoning code sets forth what you can do with your property, what kind of uses. Are those uses permitted by right? Are they permitted by conditional use? Are they permitted by exception? That's the first question. Number two, it tells you with those uses, what are the development standards? What's the maximum height? What's the minimum lot size? What are the minimum yard setbacks? All of the things that put a property on notice as to what he or she may do with their property. With the PRD zoning district is not a conventional one because it's a voluntary negotiated agreement. By definition, a PRD, the label itself, has no development standards, and that's a fact. So what has happened in this case is that as you're aware, the PRD development order, which is the document that actually sets forth the development standards for a specific piece of property, that no longer exists. It expired. So you have a label with no substance. There's nothing in it. That's why Mr. Spraker has told us and has told this board and the city commission that there are no zoning entitlements for the property because there aren't. There's nothing we can do with it. We can file all the permit applications we want, and he is not authorized to grant anything under your code. That's why we're here. We want an opportunity to have the same development rights for our property. We're entitled to have development rights for our property just like everyone else. And what everyone is entitled to in any jurisdiction is a zoning code that lists zoning districts, allowed uses, development standards. We don't have that anymore because the PRD expired, so we're in limbo. And the map doesn't revert automatically under your code. The only way that that map, the official zoning atlas map, can be changed is by going through the process for doing so that's set forth in the code. And the code sets forth the process, which is what we're here for tonight, which is the same process that you would see in any rezoning application, whether it's for a PRD or a conventional zoning district. And I'm sure you've seen many of those. Again, the difference tonight is we have no development standards today. We're not proposing a PRD, so we're not here to talk about any proposed development standards. We're asking for some. We're asking for the same fundamental right that every single property owner in this city, in this county, in this state has as a matter of law. There are no private property rights if you have no rights. We're not talking about situations where, well, I'd like more rights. I want more density. I want something more than what the code allows. We just want something. We're entitled to something. Any property owner is. And I'm sure you understand that, and I'm sure you can appreciate that. As to how this property will ultimately be developed in the future, we just don't know yet. We don't know. But we're entitled to have a minimum, at a minimum, something. That's all we're asking for, is that you provide this property owner with the same right that every other property owner in the city of Ormond Beach is entitled to have and in fact enjoys. And that's all I have to say for this evening. I'll be available for questions later if you have any, or now, whatever your preference. But thank you for your time.
Does anybody have any questions? Thank you.
Is now the time, or will we have an opportunity to ask direct questions?
Pardon me?
Is now the time if we have
Yeah,
questions to ask him?
Yeah, if you want to ask.
Okay, one.
Well, now, let's.
Okay,
Let
hold on.
me back up. You still have 10 minutes left. Does Mr. Merrill want to say anything, or are you finished with your presentation?
That's all we have to say. We're not here to present with any evidence. The evidence that we need is already in the record, so there's nothing for us to do.
Okay.
I just want an opportunity to explain why it is that we're here tonight and ask for your support.
Okay. Then, when we bring it back up to the board, we can ask our
We'll have that
questions then.
Okay, that's fine.
Okay, thank you very much.
Thank you, Mr. Chairman.
Okay, now is if the homeowners association would like to take their time, they are entitled to it. If they do not want it, then we will move on.
Good evening. Dennis Bear on behalf of Smoke Oaks Homeowners Association. I'd like to address first a procedural issue. During the last process, the developers stipulated that we would have party intervener status. I was made aware about 10 till 5 tonight that now they're objecting to it and we have to put on evidence. I don't want to further delay this process. We will raise the issue when it goes to the City Commission. I think there's sufficient evidence in my experts' reports that would establish a basis for standing. My clients are the donut that's around the hole. They're the hole that's trying to come in and now affect substantially our neighborhood. But our one expert, Max Forgy, who's worked on a number of golf course conversions around the state, pointed out in his memorandum that you received earlier in the week that the homeowners have relied in good faith for decades on the representations of the original developer in the city that this would remain open space and green space. Furthermore, and probably more significantly, the property taxes have been predicated upon the assumption that my clients and their successors would continue to enjoy the proximity to an outstanding golf course in a serene and attractive natural setting. I think those statements, which were abundantly established at the prior proceedings, clearly established as standing on behalf of my clients. I'm not going to put on evidence of that tonight, but we will address that further at the time of the City Commission. I don't appreciate the late notice. Mr. Sanders advised you tonight that he wasn't going to give you any legal opinions, and then he gave you legal opinions on property rights and things of this sort. First, in my memorandum, and I've talked to other land use attorneys around the state of Florida, there is no state law, there is no case law from any court opinions, and there's no local regulations that tell you that if a PUD or a PRD expires, it automatically reverts back to the underlying zoning. And if you look at the property here, it was zoned R2 back before any of the other development occurred. And one of the things I was thinking about tonight is you still have this blank canvas. If you give them R2 zoning, they paint the canvas however you want to. You heard Glenn Storch earlier tonight that when it comes in for site plan review, it's technical. There's really nothing that you can challenge as long as they have the minimum square footage of lots, as long as they have the stormwater. You can't say you need to protect more trees. You can't say you need to provide buffers. None of that is there. And as your staff has pointed out, if that canvas is painted under a PRD designation, then you got to help pick the colors, you got to help pick the confines. We go through the same process that was there before. And as to the issue of entitlements, there are entitlements. This property was purchased if a review of the public records was done at the time of closing, which is always done as part of the title insurance. The old 2006 ordinance was there, which says a couple of things that I think are relevant to your consideration. One is if the development order expired, that you have the right to come in and apply for a new development order. So clearly, as long as you can come in and have a process which is available to any property owner, when you buy a property that has a designation of PRD, you're not being treated any different than any other property owner. They could have sought the R2 rezoning before they took title as a condition to closing, but they didn't do it. They took it encumbered with that PRD designation. So there's no claim here that they're not being treated the same as any other property owner in Ormond Beach or in the state of Florida. The case law is pretty clear. It's in my opinion that no property owner is automatically entitled to a rezoning. Yes, they can show it's compatible with the comp plan. You've heard Mr. Spraker say, well, there's more than one designation of land use that's consistent with the future land use map designation for this particular piece of property. We have provided you with two expert opinions that both say that R2 zoning is not compatible with the existing character of the neighborhood, and I won't read those line by line, but we do have Mr. Horowski here that's going to give you a few minutes on his opinion as to the issue, because I think that there is still this issue of competent substantial evidence. All they've done is give you an application that comes up with some summary conclusions. It's compatible, we'll have some nice houses, but you have no control over what type of housing goes into that property. It could be tract homes, it could be just about anything, but if it goes to straight zoning, the city loses any input as to that type of construction down the road. As your staff pointed out, PRD allows for harmony, compatibility. The unique layout, as we talked about before, this is just not the next 80 acres out on State Road 40 that somebody might be developing. This is that hole in the middle of the donut that makes it a very unique piece of property. We've been through all the public hearings, and there's just a couple things. I know we're not here dealing with a PRD anymore, but if you remember, you were told as part of the development order review, there's no market for 100-foot lots. We can't do 100-foot lots, yet now the entire development is proposed to be 100-foot lots. It doesn't make any sense. The second part is that you were told by the developers, we want to hear your input. We want to get your views on this development. And when you told them it was too dense, they didn't want to hear what you had to say. Now they're coming back with this new application. So our position is that, again, there's sufficient evidence that we've provided in the record. Mr. Horowski is going to give you a couple of minutes just to summarize his position on the issues, that you can deny this request for rezoning to R2. And I'll reserve my additional time for closing. Thank you.
Thank you.
Good evening. In some respects, I'm sorry to be here again to have to go through this, but here we are. I provided a report to the board dated December 29th of 23, so I hope you've had an opportunity to read that. I'm going to summarize just a couple of comments from that report. R2 zoning is one of 5 zoning options that the city's code identifies as consistent with the low-density land use. The real question that we're looking at tonight is which of these 5 options is most compatible with the neighborhood. The state statute actually gives us a definition of compatibility. They define it as a condition in which land uses and conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use. Okay. No condition is unduly negatively impacted directly or indirectly by another use. And you have a policy in your comprehensive plan that supports that, and that's policy 1.1.3. And that reads, preserve the character of existing neighborhoods by not allowing the intrusion of land uses that would threaten to alter the neighborhood character. Okay. The fact that an adjacent land use might be similar in type, single family to single family, doesn't mean that they can't be intrusive or alter the neighborhood character. We've talked a little bit tonight about the hole in the donut characteristic of this property, and I think that goes to illustrate the intrusive nature of the project as it basically injects into our community. The only place where that entire parcel doesn't abut a single-family house existing in Tomoka Oaks or a lot that hasn't been developed yet is literally the driveway into the old golf course property. Because of the intrusive nature of the development, the requirement for a compatible project demands, I think, that impacts from the new development follow density and lot size compatible with the existing neighborhood. And in the report that I provided to you, we identified, and we did in the earlier hearings, identified the density of actual development in Tomoka Oaks at about 1.27 units per acre. Okay. You've heard a lot about how the land use is 4.3 and that the R2 is equivalent with that land use, but it's not necessarily compatible with our existing situation. While rezoning to R2 would seem to be an easy choice, the development of that property at R2 minimum standards, and I think that's what you've got to consider because that's likely what they're going to be dealing with to get the maximum yield that they're trying to get out of that parcel. That development will occur well above the development level for the existing housing. We're there at the minimum R2 standards, you'd be talking something that's in the neighborhood of 50% greater than the existing neighborhood. If we're to use density as a comparison between the new and the old neighborhoods, and I think it's reasonable to do that in terms of minimizing the intrusive impacts, then that table of consistent zoning classifications suggests that R1 rather than R2 is the most compatible choice after planned residential development. The resultant project under an R1 would yield a project density closer to the developed character of the neighborhood, and it would lessen external impacts from traffic and from reduced public safety that we would see with any sizable development. My comments did include a number of responses to the narrative that they supplied with the application. If you want, I'll go through those, but I think that that basically will summarize my comments at this point.
Okay, thank you. Anybody have any questions of? Okay. All right, then we'll go to the audience. And Randy, do we need to, we probably need to swear them in?
You may.
Yeah.
Not required, but you may.
Well, we did it the other one, so we probably should do it now. So I think what we'll do is when the speakers come up, is it okay, Randy, if we just have them say that, how would you want them to?
You can handle it the same way that you did at the
Okay.
prior public hearing, so.
Do you take the oath? I'll
Yes,
ask him the
and I
question.
think the recording secretary is qualified to administer the oath, so.
Okay,
And then you can have them affirm whether they did or not when they come to speak.
Okay.
So I think
sounds good to me. Okay, then the first one would be Tyler Brown.
Can't we get them all done at one time?
you can swear them either individually.
Yeah, I was
or
going to,
coordinate.
oh, you want to do it now?
It's up to you.
Okay, let's
So-
do it all
so,
at one time.
you know, So
Okay.
your decision to the board, to the city commission is advisory. It's a recommendation. It's quasi judicial proceeding, obviously. So, you know, the decision is going to be based on competent substantial evidence. And so to the extent that sworn testimony obviously is better than unsworn testimony, procedurally, it's better to swear them individually. But in proceedings like this, it's not uncommon to swear them en masse. So I think you do have some discretion. You just need to assure that when they come to the podium, whether they actually took the oath or not.
Took the oath, okay. All right, so do you want to, for all of those of you who have signed a paper, Marcella's going to read the oath, and then you can answer. I will ask you when you come up.
Okay. Do you swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Okay. All right, then thank you. Tyler Brown? Okay, thank you. Carolyn Davis?
Thank you, Carolyn Davis, 46 Oakmont Circle. I want to thank the planning board for your careful...
I'm sorry, do you take the oath?
I took the oath,
Thank
yes,
you.
sir. I want to thank you for your careful review of this R2 rezoning application. I understand the applicant is legally offended when the city or residents refer to the property under discussion as a golf course. So instead, I will refer to the property using the name recorded on the plat and in the applicant's warranty deed, which both legally describe the property as the Sam Snead Golf and Country Club. As I mentioned in my letter to you, on page 107 of your packet, an R2 rezoning of the Sam Snead Golf and Country Club plat would permanently alter the character of Tomoka Oaks Country Club Estates by locating a new, totally landlocked neighborhood in the center of Tomoka Oaks. An R2 rezoning violates the city's future land use element detailed in our comprehensive plan policy 1.1.3, which requires preservation of any bordering neighborhood's character. While the applicant is trying to make the case that they legally have the right to an R2 rezoning, I disagree, and I cite the officially recorded 2006 Tomoka Oaks Golf Village PRD development order. On pages 7 and 8 of the development order, it states that the order runs with the real property. And if the order expires, the City Commission will reconsider a new PRD application. The property is not in limbo. Nowhere does the now expired development order state the land use will revert to R2. If any planning board member tonight desires to state an acceptable density for the Sam Snead Golf and Country Club plat, I ask that you hold yourselves to the same standards as expert testimony, which requires that any number be upheld by competent substantial evidence. I suggest you cite the 2006 PRD, which was unanimously approved by the 2006 Planning Board, City Commission, our current attorney Randy Hayes, and by Rob Merrill, who represented the 2006 applicant and co-represents the current applicant. The prior PRD recorded 119 maximum units, not 119 lots, but 119 condos and townhomes. In fact, Rob Merrill described it as the poster child for smart development. I could not agree more. Thank you.
Thank you. Debbie Brown. Next up on deck is Denise White.
Yes, I did take the oath. My name is Denise White, 9 Fox Run Trail. And as Carolyn said, we've been through this quite a few times, and I too agree with everything that's been discussed back in 2006 and last year, that this development is unique and that the PRD is the appropriate zoning for such a development. As we talked about, it's the donut hole in the middle. Again, it goes back to the safety, the quality of life. Even if we're not looking at any pictures, we know that what is allowed versus the PRD limiting and guiding the way forward. And along those lines, the entrance, that's still my big concern, is the 450-foot, and the PRD allows customization, and I believe that's the way forward. And I forgot to thank all of you for your time, and also for Mr. Spraker and his team. Thank you.
Thank you. Debbie Brown now. And on deck is Darla Windnall. Did you take the oath?
I did.
Thank you.
Okay. My name is Debbie Brown, and I live at 90 North St. Andrews Drive in Florida, Ormond Beach, Florida, in Tomoka Oaks. I used to live in Daytona Beach, and when I lived in Daytona Beach, I stayed out of Ormond Beach politics. So I don't understand why someone from Jacksonville or someone from Miami is involved. I'm here to encourage the planning board to go with the staff recommendation to turn down the R2 zoning request of Tomoka Reserve. Tomoka Oaks was always meant to be a golf course community. 75% of the streets in Tomoka Oaks are named after worldwide golf courses. Developing 317 homes inside instead of 242 inside an already existing development is improper. The owners of Tomoka Oaks has indicated several times a willingness to purchase the property only to be ignored or ridiculed. Yes, the owners have had several meetings with Tomoka Oaks only to be controlled by Tomoka Reserve attorney or staff. I don't believe this was the purpose. From the beginning, Tomoka Reserve owners were requested to not try to overdevelop the land and were requested to have adjacent 100-foot lots adjacent to 100-foot lots. Now I speak to Tomoka Reserve people. Remember, you purchased a golf course, not vacant land to be developed for profit. And I guess the last question I have is, what rights do I have as a property owner? if I don't have any rights.
Thank you. All right. After Darla Windahl, we have Paul Hughes.
Darla Widnall, 7 Shawnee Trail. Regarding the 3 main intersections that would be affected by this proposed development, Tomoka Oaks Boulevard and Nova Road, Main Trail and Nova Road, and Main Trail and Granada Boulevard. Each of these intersections would need at least an extra right turn lane that is required to be 400 feet in length. Imagine that. Regarding our traffic study, we have only had 1 traffic study done with a follow-up traffic study. Both were done by Mr. Lassiter's company, who were hired by the developers. The city has only hired a traffic engineer from DeBerry to comment on these traffic studies. The city has not done their own study. You can imagine how much we are believing the traffic study paid for by the developers, such as when they say that only 4% of traffic will be coming through the trails. Regarding the traffic signal at Tomoka Oaks Boulevard and Nova Road, don't be fooled. If you believe a traffic signal will help, the Florida Department of Transportation has not approved a traffic signal. They have only said they would consider it. Traffic engineer Mr. Lassiter, who thinks a traffic signal is a good thing, said he would not recommend a signal at that position some years ago because it would cause too many rear-end crashes. Imagine that. Regarding gopher tortoises, the developers were in violation of state law when they demolished 20,000 square feet of buildings on the golf course without obtaining a gopher tortoise permit. Thank you. Thank you.
Thank you. Next, Paul Hughes, and then on deck is John Maisel.
My name is Paul Hughes. I have taken the oath, if that's satisfactory to you. I live at Forlorn Court. I've lived in the neighborhood for about 30 years. And I'd like to know, state for the record, there is a use for the land as is. Some people know it. I did offer to buy the whole golf course when it was up for sale. And I just wanted to put 1 home on it. Now, my wife wasn't happy about the idea, but you can put a home, single-family home on it. And if I wanted to let the land revert or have a buffer or have a golf course for my friends, I could do that. So there is a purpose the way it is. Now, 1 home, 1,000 homes, somebody will figure out the difference in between it. There's precedent for doing this. I've done this before with a school up in the Panhandle and bought 50 acres or established 50 acres so they wouldn't have to worry about the buffers. You can come in, white knight it a little bit, and basically buy some peace because no one's determined the value of the effect of all this gyration on the neighbors. The angst in our neighborhood is horrific. There are people that are suffering from the anxiety that this is all causing. Now, behind the new iron gates that are installed recently down there, there's some demolition. If somebody looks at it, you'll see that the parking lot that was historically there had leaded cars on it for years. There are studies that have to be performed before you tear up anything that has leaded gasoline particulates in the ground. I don't believe any of that has occurred, nor have there been studies of the aftermath of that. Now, the dangers of that could be that the particulates go airborne, like lead dust, and pica can be established with small children, or people that have autoimmune deficiencies might have some problems with the soils and the airborne particulates that are there now because there's nothing going on. There was no reason to destroy it, but for some reason they tore down the old building and the warehouse or storage facility that was on there. The soils have been in question since 2006. There are many people that were concerned with autoimmune deficiencies then, and they were reassured by the attorneys at that time that this was not going to be a problem. It seems to me that history is repeating itself, and I suggest that the town consider establishing a significant buffer all the way around the golf course till this is resolved and properly tested, and all the parties are agreed to the testing, so the HOA, the board, and the current out-of-town speculators can also be involved in that, so it's a fair decision and study. Thank you.
Thank you, Paul. All right, next is John. On deck is Kristen Deaton. Did you take the oath, John?
Yes, sir, I did.
Thank you.
My name is John Measle. I live at 16 Eagle Court. The golf course, for one, should have never been allowed as zoning R2 due to the density. Even Mr. Merrill stated that the developer team didn't think 317 units would ever be a good fit this property. I think it was 2 planning board meetings ago. One of the biggest problems with the R2 zoning is the majority of houses built on the golf course were built to utilize the golf course as their backyard. You can walk around the actual edges of the golf course, and the majority of houses are set right at the minimum of 25 feet. Some of the houses actually have their pools and their pool enclosures within inches of the property line. So there's no way you can build houses that close to all these other houses that are set right at the bare minimum of setback without affecting their property values. I don't care if they're $600,000 houses like they said before or not. This property was previously said to be a PRD for a reason. The streets around Tomoka Oaks were set up for the amount of housing in the area, counting the green spaces of the golf course. Anybody driving through that area knows, I guarantee you there's one near miss a day on those streets from pedestrians or bicycles almost getting hit. The density is the main issue here. I know the city can't afford to upgrade St. Andrews North and South, Rio Pinar, or Main Trail, including Meisner Bridge. The developer's never going to take on this project, so the planning board was able to develop a hard number. Well, I'll even skip that part because we don't need to, that's PRD stuff. So if they insist on getting a zoning, I say either give them R1 or make them go back to a PRD. That's all I got. Thank you.
Thank you. All right, Kristen Deaton, and then on deck is Tom Fitzgibbon.
Good evening. Yes, I've taken the oath.
Thank you.
Kristen Deaton, lifelong Ormond Beach resident. Planning Board, I encourage you to use your conscience when making this vote. A project that we didn't like at 272 homes, we're definitely not going to like at 317, whatever other magic number they come up with. There are just more viable solutions than this. I know and trust that you will make the right decision. Have a good night.
Thank you. All right. Tom Fitzgibbon, and on deck is Jeff Bowl.
Darn, I thought I'd have more time there. Okay.
Well, you still get 3 minutes.
I have taken the oath. My name's Tom Fitzgibbon. I live in Tomoka Oaks. And Tomoka Reserve is a pedestrian and traffic safety hazard for the current residents. In and around Tomoka Oaks, the trails, Escondido condos, Talaqua, Nova, and Granada intersections. Several years ago, 4 houses down from our house, a woman pedestrian was killed by a driver around a blind curve. I have seen a city inspector almost get hit by a car. I have seen large delivery trucks speed around blind curves and clip overhead wires and trees many times. None of our old, narrow streets have sidewalks. When I walk, run, or bike, I am in the street, surrounded by cars and trucks whizzing around me. The narrow, curving tree and shrub-lined streets and traffic islands obstruct driver views and put kids in danger. Utility trucks park in the street at all times during the day and night, further obscuring sight lines and causing drivers, pedestrians, bikers, baby carriages, and dog walkers to play a deadly form of dodgeball with traffic. Predictions from LTG, hired by the developer, call into question their data and methodology, adding 600 plus cars and 3,000 plus trips daily in a 2-lane road, Tomoka Oaks Boulevard, and a standard stop sign intersection will cause more accidents. Many people will choose to drive on South St. Andrews and Trails roads. Our old development was never designed to support the additional traffic that Tomoka Reserve will create. I am asking the Ormond Beach Planning Board and Commissioners to significantly limit the number of houses to 122, the original 2006 PRD number, and to consider the 2006 PRD the gold standard for any new development. To require the developer to finish street work before house construction begins. That includes new sidewalks on both sides of Tomoka Oaks Boulevard. To require the installation of a light at Nova and Tomoka Oaks Boulevard before house construction begins. To allow for heavy construction traffic flow. To require a comprehensive new traffic study due to the changed development layout and increased number of houses. And to please consider saving Tomoka Oaks Golf Course as a public course or other open space Once filled with houses, it will never be available again. Tomoka Reserve is a traffic safety hazard. We appreciate your help and to limit the danger to our children and families living here. 6 seconds, huh? I'm no legal eagle, but the developer was negotiating the PRD because they realized the property was unique. Then when they didn't think 272 houses was enough, the developer decided to drop their PRD and is now complaining they have no property rights.
Thank you.
Thank you for listening.
Thank you. Jeff Bowl, and on deck is Bonnie Kofor.
Jeff Boyle, 614 North Halifax Drive. The truth, the whole truth, and nothing but so help me. Hundreds of residents, this board, and the City Commission have pleaded for a density reduction for this project. 272 units were voted down, and now the applicants are back seeking a rezoning so they can build 317 units. Attorney Sanders calls any attempt to reduce that number, quote, an exercise in futility, and has threatened legal action if the city does not approve the rezoning. We ask for less development, they give us 45 units more, and withdraw the promise of a Nova Road traffic signal. 6 public hearings since last January, moved from City Hall to local churches to accommodate massive community turnouts, and a 12-month public outcry protesting density, increased traffic, and impacts on adjacent neighborhood property rights. The developers have ignored these citizen protests voiced at a neighborhood meeting, 3 planning board hearings, a city commission meeting, and here at your board again tonight. The developers assert compatibility with both the letter and the spirit of our land codes, claiming an automatic right to a rezoning that will exempt their property and project from planning board and city commission review. We are here tonight because rezonings and approvals are not automatic. They require public hearings, public testimony, and votes. Applicants have property rights to develop the land, but local governments and advisory boards get to decide how. This project fails
every test. That's why they had to make threats against our city. Please weigh only the facts and reject this rezoning. Thank you.
Thank you. Bonnie Kiffer and then Michelle Zirkelbach.
I did. Bonnie
Did.
Clover, 23 Tomoka Oaks Boulevard. Well, here we are again, and has anything changed? Did around 1,100 Tomoka Oaks Trails people and Escondido residents wake up one morning and say, wow, it's a great idea to have at least 1,200 additional vehicles coming in and out of one route per day? I don't think so. Did the developers come up with and seriously want to work with the residents? I don't think so. They have come back with a vengeance and now want to put in their 300 or whatever homes crammed in there. We all don't want it. The planning board didn't want it. And to top it off, the city council didn't approve it. Why? Because it's just not right. What has been fixed? Do you really expect us to believe that a traffic light at Nova Road is fixing around additional traffic of 1,200 cars per day? Did they come up with another entrance and exit? Did they come up with more schools? Did they come up with more hospitals, doctors, or roads? They have come up with nothing but their fancy so-called experts waving around degrees and no serious solutions to our problems. And the very interesting gentleman who showed up at one of the meetings, who didn't even live in the area, thought it was a great idea to cram in all those homes. That was a cute little touch. They have come up with nothing but lots of money and fancy lawyers. They keep trying to cram their big fat feet into Cinderella's slipper, and it doesn't fit. Thank you.
Thank you. Michelle Zirkelbach, and on deck is Mariah Zirkelbach.
Good evening, Michelle Zirkelbach, 328 River Bluff Drive. I did take the oath.
Thank you.
I want to start tonight by saying thank you to the city staff, the planning board, the city commission, and a host of volunteers. I know I'm not going to be able to name them all, but Jim Rose, Mary Greenlees, Tom Fitzgibbon, Denise Corley. We've got Carolyn Davis knocking it out of the park. I'm telling you, Jeff Boyle, Tyler Brown, my partner in crime, Missy Herrera. We do a little golf cart door-to-door action to make sure the residents know what's going on. And then there's Ashley Dufresne. Ashley appeared before you guys last 9 months pregnant. She's not here tonight because she had a beautiful baby girl. I was authorized to speak on her behalf, and I got a text from her, and she said, I just can't. My hands are full. And this was her quote that she wanted me to share. I am still opposed to this development. We, too, have property rights. I remember very well being in her shoes when we moved into our dream house in Tomoka Oaks with a 4-year-old and a 2-year-old in tow. They're here tonight as a 27-year-old and a 29-year-old, and I think they would both tell you they had the most amazing childhood. I wish the same for Ashley's daughter. I want them to have carefree walks. I want them to ride their bikes to their friend's house. I want them to listen and watch for the wildlife. I want to hear the sounds of laughter at an amazing game of manhunt. I'm worried that that won't happen. Common sense tells us the traffic study is not right. Common sense tells us that our roads in Tomoka Oaks are not designed for any amount of additional traffic, even remotely close to what the developer is proposing. We have a lifestyle in Tomoka Oaks. This traffic would severely impact that, and it's not right. Earlier tonight, I think I heard the applicant's new attorney state that the PRD failed. That is not an accurate statement in my opinion. I don't see it that way. The PRD process was working. The only thing that failed was their plan to give them what they want. It did not reflect what the residents of Tomoka Oaks or the citizens of Ormond Beach want. Mr. Rubin has a habit of going in and asking for a little bit more after he gets what he initially wants. 5 units per acre becomes 8 units per acre. We have 6 dwelling houses where it was supposed to be 4 dwelling houses. I want you to know that the wisdom of my 27-year-old said, why aren't we trying to build it better? I have my daughter's 7th grade citizenship project on here, what we want, open land, we want space. What we don't want, a bunch of junk jammed in a donut hole.
Thank you. Mariah Zirkelbach, and on deck is Mary Greenlees.
Hello, I am Mariah Zirkelbach. I live at 328 River Bluff Drive. Tomoka Oaks is a place...
Did you take the oath?
I did,
Thank
sorry.
you.
Tomoka Oaks is a place that has prized quality over quantity, quality of living, quality of housing, and in my case, quality of childhood. In a world where children are becoming further removed from being children, those who are looking to choose quantity need to reflect. My childhood was quality, not just due to my family, but where I grew up. My imagination would fly as my brother and our friends came up with games just to stay outside. I could easily travel from house to house without my parents worrying. I had the ability to get to Rainbow Park, the shopping center, the bike trails, all on my own. I guess you could say that is where my independence is rooted from. Even now, as I look to purchase my own home, I think back to the freedom I had, the tall oak trees that never seem to end, the endless memories and friendships that keep me grounded in who I am, even as an adult. Shoving 317 houses where they are not required nor necessary is for one purpose: to line the pockets of those whose pockets are already full. We, the actual citizens of this town, are entitled to quality of life and the well-being of Ormond. From where I'm standing, there is enough quantity. It's time for this developer and his team to get back to quality. Thank you.
Thank you. Mary Greenlees.
Good evening, my name is Mary Greenlees. I live at 94 North St. Andrews Drive. I've lived there for almost 25 years, and I've taken the oath and strongly oppose the R2 zoning. This has truly been a missed opportunity. If we were only informed of the 2006 PRD expiration, we wouldn't be here. Ironically enough, in 2006, I was going through breast cancer treatment. We thought 119 townhomes was a great plan, as we may had to have downsized. It was truly a poster child for smart growth, hence why it was approved so quickly. Now, 18 years later, they are asking for nearly 3 times that, offering a 6-foot buffer. Most of you know I've been pushing the park option. I've done my research on how a CDD, a community development district, works. Our existing residents would need a 100% yes vote, so we all know that won't work. If we can't, why can't they? Talk to Maury Husseini at Intervest Construction. They've done this with great success. Create green space, adding value to the neighborhood, and then spread the cost to the new lot owners. The planning board recommended we meet with the owners and try and come up with some kind of resolution. I personally met twice with Dwight, Ray, and 2 of our committee members. After 5 hours of 2 meetings, the outcome was a reduction of 4 lots. Facts. This project has been in the works for over 3 years and validates that the developers will continue to go through hurdles. Fact, our Ormond Beach Commission, Planning Committee, Mayor, City Attorney, Assistant Manager, and Planner have our backs. They care about Ormond Beach, and I think it's the best I've seen in years. There is a new neighborhood built at the Halifax Plantation called Wind Chase. Homes start at $700,000 with 3-car garages built on estate lots, and they are selling. Tomoka Oaks, The Trails, Escondido, and numerous Ormond Beach residents are vigilant, they're smart, and they will continue to support their position. There is not one Ormond Beach resident that is in favor of 317 new homes built in the middle of town. Somewhere in the middle works. Think out of the box. That's what needs to be done. Maybe a mediation. The developers deserve to have a return on investment. The real question is how much and how long they're going to have to wait. I vote for R1 estate homes on beautiful lots in the middle of a beautiful town that start at $700,000. Thank you very much.
Thank you. I'd like to thank everybody tonight for speaking and giving us their input, from the applicant to the residents and everybody in between. Now we will bring it up. We'll close the public hearing. We'll bring it up to the board. Yes, Randy.
You may want to ask if the applicant has any additional testimony or anything they want to provide.
All right.
Yes? No? Okay.
Thank you, Mr. Chairman. We don't have any evidence to present to you, and respect your time, and are available. I'm available for any questions that you all may have, but the evidence that we need that's in the record is already there.
Okay,
We're happy to answer any questions that you have tonight.
Just a second. Gigi, you had a question earlier that you were going to ask. Now would be a good time.
I'll cover that. We'll have general discussion.
Okay. All right.
I'll
Thank
cover
you.
that in general discussion.
All right. So now we'll bring it up to the board for discussion. So, Mike, you know you're always my leadoff hitter.
Yeah. Ricky Henderson. I'll just say I've listened to everything that was said here tonight. Read through most of this packet. I'm not going to lie and say I read every page, but then again, this is very familiar to some things we've seen prior. With respect to this zoning issue and the rights and or entitlements or lack thereof on this property, I guess I'm just sort of different. If I buy something, I'd like to know what I'm buying. And in this case, it sure seems to me like the applicant bought a piece of property with no entitlements, as was said here tonight. It's like buying a car without an engine. Seems like a bad idea to me, to come and then ask after the fact for considerations that are not granted within the purchase and the contract that you signed on the property. So I'm not moved by that, and I would be comfortable voting yes to follow the staff's recommendation and deny this request.
Troy?
So I wrote some comments down. Mr. Baer said it very eloquently, and I appreciate his position, and it is aligned with my thought process. Originally, the Tomoka Oaks area contemplated what should be there and developed around it. We've said it, and I'll reiterate it, moving forward to 2006 to the expiration of the PRD. The issuance of a PRD development and then the expiration of it, it was identified and assigned and allocated. If we're going to put houses there, or we're going to put some type of residential unit count there, here's what's palatable. And I don't think there's any number higher than that that is palatable. We certainly haven't seen a plan that shows something that takes into consideration all the feedback and input that allegedly the developer's taken into account. The new gentleman who spoke, Mr. Sanders, talked about the history. One of the residents, I think, very poignantly identified what the name of that property is. So there should be no question, as Mr. Scudero indicated. I feel the same way. When you buy something, you know kind of what you're getting and what you can and can't do with it. And I think one of the last comments I think is very poignant as well, is the process of the PRD and in what you're allowed to do is working. We're trying to identify something that's palatable for the community. You know, the developer voluntarily purchased the property with those labels and those entitlements or lack of entitlements. Back to the donut, you know, if you fill the donut with non-conforming use or, you know, bad ingredients, I mean, it's not only going to taste bad, it's going to, you know, kind of make you sick. And, you know, they're looking for sweet jelly to kind of explode the whole donut hole in the whole donut. So I'm personally not in favor of moving away from the PRD at all.
Angie, you want to go next to last, or you want to go now? Okay. Barry?
Sure. First of all, I'd like to admire all the logic from the Tomoka Oaks residents. I ran a $450 million business, and I surrounded myself with logical people, and I'm fully impressed with everybody that presented their case today and over the past meetings. I recall in the first meeting, I mentioned Broadwater, and here's what I don't understand. It goes back to the logic issue. If we went with an R1, which I basically think is what Broadwater is, you're looking at approximately 75 homes there. If you develop these kind of estates on that piece of property, I think that would be a jewel for the developer. I think he would walk away with whatever revenues that he's looking to get from that. It would be an increase in the property values for the surrounding community, as well as Ormond Beach, saying we have another jewel in our community as far as this particular project. I don't understand why you have to cram this many homes in here and just absolutely saturate our infrastructure that can't handle it. I'm concerned about the 3,000 homes that are going to go in Ormond Crossings. I mean, that's going to increase more issues. And what happens is, and that's why I agree with what some of these people said about the traffic studies, is that how do we handle something if there's a catastrophic effect? If there's a storm, you're going to have gridlock. You have to limit this. I really believe that either the original PRD of 2006 or an R1 should be accepted. I think the developers need to take a second look. I think you can make a good profit. I think you can use this as an advertisement saying, we developed this unique community that everybody came away as a winner. So I would definitely deny any R2 insistence of putting that kind of a project in place, and I would go with the original PRD or an R1. Thank you.
Thank you. Al?
My position on this project hasn't changed from the time I drove through the development, probably for only the second or third time since I've been down here in the last 35 years. And as it's been proposed, it has never struck me as being consistent with the character of the neighborhood. The density issue has bothered me significantly, and for not just the density in the residents, but what it does to the existing infrastructure, which was never really designed to handle that. And that's somewhat common, what happens in many areas of the country where the infrastructure never catches up to the development. And then it gets horribly expensive to try to fix that downstream, i.e., see what it costs you to build a mile of road expanding an interstate property. The challenge that I had in looking at this and its uniqueness was that if we were to do something and approve something for that area, it should be at the it should be above and beyond anything that we've ever really done in Ormond Beach before. We should be moving toward excellence and not just whatever the common practices are, even in other communities. It's a special community and it's a special spot. It might even be that it might be necessary to create a special zoning district just for this type of property that would be translatable across many communities where golf courses have been in the center of residential developments and they no longer exist. So we might set an example that could be done on a countrywide basis based on how we handle this particular transaction. The PRD obviously gives the city a tremendous amount of leeway in terms of how it gets developed, and it's a compromise vehicle to try to work with the developers so that we have economic development that we're looking for, but economic development with compatibility. I would prefer to go even beyond what was in the PRD and thinking more in terms of what can you do with that piece of property as something that maybe is at the top end of an R1 district. But that's a discussion for another day. I can't support an R2 designation for this property. It doesn't even become close to what we think we were looking for in terms of how we want our city to develop and how we want our residents to be comfortable in decisions that they made many years ago with respect to what they anticipated their families would grow up in and their commitment to come to Ormond Beach. So my decision was made with respect to an R2 designation. I could never support it.
G. Carl Sanders, maybe I came down a little rough on you, but if you'd been here back on the apartment complex that they threatened us, so you're getting the end of the ninth inning, so to speak, of us being threatened and bullied, and it's now time that we stand up to the land use attorneys and we work together instead of threatening us with words like, I'm gonna go nuclear on you. Not you, but what they've been said in the past. I do want to talk a little bit about the God-given rights of property rights. Yes, everybody has property rights. You as Tomoka homeowners have property rights, but let's just think a little bit. The owner had the right to sell that property. And I know the Tomoka Oaks Homeowners Associations had the right to buy that property. I even came up 6 or 9 months away, and I believe Mary mentioned it, a way that y'all could buy it and put it on your tax bill over 30 years. I think that night only about 15 people raised their hands that they were interested in doing that. There were individuals within the community and with the homeowners association that tried to buy that property. I know of 3 groups that tried to buy that property. So when it comes to property rights, I'm not up here to tell a developer what he can or cannot do. I believe in trying to live within the guidelines that we have. Somebody mentioned earlier that unless we were a civil engineer or an engineer, we didn't have the right to tell how many lots. Well, I'm using Tom Horowski numbers. And if I heard you right, Tom, your numbers of 1.27 units per acre, and there's 147.94 acres. And if this phone was working right, you would be happy with 187.88 homes, approximately, plus or minus. So your own group, I've always said something is going to go within that hole of that donut. There's many times y'all heard me say I could support 222 homes, but since tonight, the most I can support, because I'm not a civil engineer, is what Tom Horowski said. He said 187 homes. So I do believe that somebody has the right to build 187.88 homes, but I will not be supporting R2. I just will not be supporting it. And in some form and fashion, either y'all as individual homeowners and taxpayers that, I heard the word let's maybe turn it into a golf course. I have a property rights too that my tax dollars should not be used to buy that property to turn into a golf course that didn't exist, that cannot continue to exist as a golf course. If y'all as individuals want to buy it and donate the land back to the city and open up some public golf course. But I do not want to see any of my tax dollars used to turn that back into a golf course. So my attitude is I cannot support R2. I can support, I believe, the staff's recommendation of PRD. But just remember, we all have property rights. The buyer has property rights. Everybody in that community had property rights to buy that property, but nobody stepped to the plate to buy it. So, but I will not be supporting R2. But as I've always said, I've been very transparent. Something will be going into the middle of the donut. It's just a matter of what I'm hearing tonight is the density is what everybody is against.
Before I come to you, Randy?
Yes, sir. When you're done, I just want to share some observations before you make a motion, whether it's now or whether you want to.
Okay, cool. Yes, sir.
It's up to you.
Angie?
Okay, I have to agree with everybody up here right now. Mr. Scudero said the developer knew what he was buying when he bought it. So that's what I keep coming back to, is if you knew there were new entitlements, you should have taken care of that in the beginning. You should have been prepared for that. And I don't feel sorry for you. You have a ton of attorneys and experts that are telling you what's going on with this property, so you should have known what you were getting into. The PRD, I think, was the best way to go about things. It was supposed to be a voluntary agreement, I think is a terminology that I read, between the developer and the city. Now, again, as somebody up here stated, we were working on that. You kept coming to us stating, please tell us what you want. We heard that in neighborhood, 4 neighborhood meetings, 3 planning board meetings. Tell us what you want. And we did. We told you less density. And you weren't willing to make even the we had the slightest change to like 3 or 4 homes. So it's very frustrating for you to come back now and say, oh, well, now we want R2. So we can put more homes in there, because the whole point was that was the main point, was we didn't want that much density in that property. I have to say also that I agree with Mr. Galloway's opening statement about this letter. I didn't appreciate it. I don't appreciate being threatened, and this board knows that we have developers come before us all the time that say these things to us. Well, if you don't do this, we're going to do this. And it's getting old, and it's getting very aggravating. The people of the city own this city, they run this city, they vote their commissioners in, and they have a right to say what they want to say, and which they have done. The property owner does have rights, but I feel like they knew what they were doing when they purchased this property. So I would have to say no to R2.
Anybody, excuse me, anybody that knows me or has attended any planning board meetings that I've been on realize that I've always had the philosophy that a property owner can do with their property what the code says they can do with their property. When they bought this piece of property, the code was a PRD. To my opinion, it's still a PRD and should always remain a PRD until a better solution comes up. R2 is not that better solution. I kind of apologize for my beginning statements at the beginning of the meeting, but quite frankly, I really get ticked off when somebody thinks that they can intimidate me or push me around, and I take a little bit of exception saying that letter was not meant for us, because if you know anything about how planning works and how a planning board goes, every piece of material that comes into a subject that we are going to discuss and make a recommendation on is handed to us. Here are letters and stuff that I just was on my desk just now when we showed up. So every piece of anything is public record that comes to the planning department or to the city, and we have to have that information. So I take a little exception on that it was not intended for us, because it dang sure was. So again, a person can do what the code says they can do. They've had ample times. We have tried, we have told them tell us what you want, tell us what you want, tell us what you want. 3 times we have told them what we want. And 3 times they've just walked away and said, to heck with that, we're not doing that. So here we are, and it's going to be, as I can read, kind of a unanimous decision. But before we have the vote, then Randy, you wanted to make...
Yes, sir. I want to kind of refocus everybody to the specific issue.
You always do.
Thank you. So the issue before you this evening is an application to rezone the property, not to develop the property. I do want to also want to mention that my comments, they're not testimony. Comments from Mr. Bear on behalf of HOA, that's not comp to substantial evidence, nor from Mr. Sanders, right? That's just legal opinion. It's instructive, you can take it for what it is. But I do want to draw a distinction first between the PRD zoning and development process and traditional zoning. So the PRD zoning is a flexible zoning district that is intended to allow flexible uses in a zoning district, conventional zoning district that is not otherwise allowed. The development orders that are reviewed and considered and vetted and ultimately approved generally, those are not negotiated contracts. We do not enter into a PRD development agreement or a PRD development contract. These applications are reviewed as any other application for development order, and conditions for the development of a project are set forth in that development order. So we do not negotiate PRD development anything, okay? So I just want the record to be very clear on that. But back to the issue. The narrow issue before this board is whether this property should be rezoned from PRD to R2, all right? So you heard a lot of other discussion about components of development, and to the extent it's relevant to whether the property should be rezoned, then you can give it whatever weight you want. But you're not here to parse out the details of a development for the property, because that's not what you have. But the burden is initially on the applicant to produce competent substantial evidence, not through attorneys' opinions, but through witnesses and testimony and experts, to demonstrate why they believe the property should be rezoned. In other words, that it's consistent with the comp plan. It complies with the land development code and other applications of the ordinance, right? It's their burden to do that. If they do that, then the burden shifts to those in opposition. HOA, you've got a staff report that recommends denial for the reasons stated in the staff report. Then the burden would shift to the opposition to produce competent substantial evidence as to why their position should be approved over the applicant's. What I'm struggling with here is I didn't hear any competent substantial evidence from the applicant at all on this rezoning application. I understand they're relying on what's in the record, but they haven't parsed out to you specifically what information or competent substantial evidence in the record they're relying on. So you're going to have to figure that out, I guess, in your decision-making process. Notwithstanding that, so there's a question as to whether or not they met their burden and whether that burden shifted over to those in opposition. Notwithstanding that, the HOA did, you did hear from Mr. Harowitz, who I believe is an expert in these sorts of things, and he explained to you his opinion, his professional opinion as to why he thinks the rezoning application should be denied. In addition to that, you have the staff report that identifies the criteria for the review of the rezoning application. And in the staff report, that is on pages, I believe, 12 through 16. And in the recommendation of the staff report, they give you the reasons why they believe the R2 rezoning application should be denied. And you also heard testimony from a lot of other resident witnesses this evening, including discussion about other zoning categories, R1 through whatever it may be, the 5 different ones. So the decision you have to be has got to be based on competent substantial evidence. You got to figure out where that comes from. You got to determine whether or not the applicant met its initial burden to cause the shift that burden over to the opposition in support or opposition of the application. So you need to give that some weighted consideration in your decision this evening. We need to stay away from the components or elements or features of a development on the property that you would like to see, and focus your discussion solely on whether or not the applicant has met its burden to have the property rezoned to R2. Does that help?
Thank you.
Okay, it's all yours.
Everybody have any questions of Randy?
Can I ask a question?
Yes, absolutely.
Randy, are you saying then if, to get this moving one way or the other back to the city commission, would we say, okay, we reject the R2 and recommend the PRD as per staff recommendation?
So
to move it on, and then does that go to the city commission, or do they come back to us as a PRD?
Well, we don't have a motion yet.
No, I'm just saying in scenario.
I mean, I can help you with the flavors of the motion once you get something on the table. But I think that your focus your attention should be turned to who has the burden and was that burden satisfied? And what was the evidence to support that burden? And then from that should help you or somebody make a motion for purposes of whatever you're going to vote on. And you can certainly rely on the planning staff's professional opinion if that's where you're leaning. I think you are based on what I've heard. If you're going to make a motion to approve the application for rezoning, again, it needs to be based on substantial evidence. I understand from the legal arguments from counsel that they're relying on the information in the record. I'm not a decision maker, I'm just a lawyer. So I don't know what they're referring to. You're going to have to figure that out evidently as well. So that's up to you.
Well, you think I'm an attorney?
No, but you're a decision maker.
Mr. Chairman, if I may, so would it be, Mr. Hayes, would it be prudent for us as a commission to individually state and maybe answer questions such as, do we think the burden shifted? Do you think, if it didn't, do we feel that we were provided compelling reasons why R2 zoning should be considered? Something like that. Is that what you're suggesting?
I'm kind of struggling with this along with you a little bit. What you might do is you might break them down into some subparts. And one question the first one might be whether you believe that the applicant provided competent substantial evidence to meet its burden that the application for rezoning to R2 should have a vote of approval. And if you believe it does, then you should base that on some competent substantial evidence. If you don't believe that the applicant has met that burden, then I think that box is no, the applicant did not meet its burden. And then the subcomponent of that then is that the burden does not shift over to the opposition, but based on what you heard in your deliberations, I think it would be appropriate for you to rely on the professional staff report and any other competent substantial evidence that you believe supports whatever decision you want to come up with. Does that help?
Yes. Yeah.
Well, I think to that end, I'd like to make a motion, and I had already been kind of leaning this, and maybe I should have led off with it, Chairman. I am most stuck on one of the items identified by staff and certainly verbalized several times here tonight, that these local roads are not equipped to double the traffic that they would see from the R2 zoning. So based on that, I find that the staff's recommendation to be in order for denial. So I will make the motion to deny and support the staff recommendation on this request.
All right, before we get a second, if anybody else wants to give their reason why they feel that it was or was not presented for a reason for acceptance or
Yeah, so that's where I was going. I will state for the record that I do not think that the burden shift. I don't think there was evidence or anything that was presented to support R2. And to that extent, the other testimony that we considered further supports that the mountain for them to climb to establish and that R2 zoning is conforming or should be considered isn't there. And if the burden shift, I'm comfortable with the evidence that we were provided that support that we would oppose it.
Barry?
I concur with Troy.
Al?
I think the reason for the staff's recommendations are sound. I don't think the applicant has met the requirements for the R2 application. And with that said, I would concur with the staff's recommendations and the city's council's recommendations with respect to a denial of an R2.
G?
I agree with what everybody said. I think we need to break them down into separate silos. I think we need to vote on, they did not reach the statute of the burden. And then we vote on that. And then then Randy, correct me if I'm wrong, when I heard you, like I said, I am not an attorney. And then we vote on what we want to recommend, and we take the recommendation of staff. I think they need to be pulled apart.
Did you?
I agree with what everybody has said up here, every single person. I really can't add to any of it. I don't think they've met the burden of proof.
You know, and Randy will probably might have kind of something to say. Maybe I'm saying something I shouldn't, but this is starting my 34th year on the planning board. And in all those years, I've never had somebody come back on a board that I'm on and say, well, we should move it back to this because that's what it used to be. Well, hell, there are a lot of things I used to be. And just because it used to be is not meeting to me, is not meeting the burden of proof. And also, there's so many things, the recommendations for denial that was from the staff that I totally agree with. So I'm kind of on one side, they met their burden of proof. On the other side, well, it just used to be that way, so let's do it that way now. That doesn't cut it for me. So that's my reasons that I'm going to vote no. So we have a motion on the floor. Troy?
I think Randy was going to
Oh, Randy, were you going to say something? I'm sorry.
So Mike, I think you made the motion to deny, right?
I did.
And can you restate that? Sure. For the record, I'll try to help you with it based on my understanding of where you're trying to get with this.
Sure. Based on the testimony heard here tonight, based on the recommendation by staff, I am concerned that the applicant has not shown us any evidence to suggest that the traffic concerns, both in the report and heard here tonight, are invalid. And so for that reason, I am making a motion to follow the staff recommendation and deny the request.
Okay. So let me try to restate it. I don't want to put words in your mouth. So, so your motion to deny, I guess, in legal terms, one is this board does not believe that the applicant met its burden to provide competent substantial evidence to show that the property should be rezoned to R2. Two, notwithstanding the failure of the applicant to provide substantial evidence, it's the board's position that the opposition, the HOA in particular, through the testimony of Mr. Harowitz, did provide substantial evidence to show why the application should be denied. And I guess specifically there were some discussion of 5 other zoning categories. And thirdly, relying on the recommendation of the city staff report. Is that a fair summation, I think, of where you're trying to get? Okay.
Yes.
I'm not trying to make your motion, I'm just trying to understand, I think, collectively where you're at. Is that, Mr. Railsback, I don't think you seconded the motion, but is that generally what you're trying to accomplish up here?
If that was Mr. Scudero's motion, I will second it, yes.
Okay.
Based on your summary.
Okay, I'm just trying to help guide instructively, so.
That was my comment on his motion, and so if we've summarized that without changing it in that manner, that I will second that motion.
Yes.
Up to you.
Okay, so we have a motion, we have a second. Is there any discussion? Hearing none. Marcella, would you call the vote, please?
Yes. Mr. Scudero?
Yes.
Mr. Railsback?
Yes.
Mr. Demulin?
Yes.
Mr. Jorzak?
Yes.
Mr. Galloway?
Yes.
Ms. Shaw?
Yes.
Chairman Thomas?
Yes. Okay, so we have completed that part of our evening. We have some more items to cover tonight before you can go home, but we have a couple more things we have to do. Thank you for coming. We appreciate your input. Okay, so now we'll move on to public comments. We have, I'll wait a minute for the room to clear. Okay, now we'll turn to public comments. I didn't have anybody turn in any cards who wished to speak tonight, so I guess we have no input from the public. Is there any other business that anybody may have?
Wait a minute.
Any other business?
Any other business? Gee? None? Nobody has any business? All right. Any other business? No other new business? Now we'll go to members' comments. And G, want to start with you?
Sure. I was in Tallahassee for the last 2 days, and one of the concerns that many politicians are having is that we are being buffaloed by a lot of there's 3 developers within the state that are basically really buffaloing planning boards in cities on their planning departments and stuff, and we've got to do what we did tonight and not fold to what is the quality conditions of what you want in a community. And you're going to start seeing more and more of this where they push to the max and push to the max and push to the max, come back for more, and then they threaten you. And I apologize that I kind of hit the turning hard, but I just came out of almost a 2-hour meeting today where this is happening all throughout the state. And it's up to us to stop it at the planning board and the city commissioners. If not, they're going to start. This is a growing state, and people are going to continue, and people are going to be built, and they're going, developers, and I'm one, and I sell commercial real estate, they're going to keep on asking for the max and max on everything. So once this community gets to be known as they'll give you anything, I'm just saying, get prepared. We're going to see more and more of these type of proposals.
Al?
Yeah, I was following a little bit of the activity with the Belvedere suit now over in the county over the industrial district, and it just struck me as in line with what Gigi was just saying, is the developers are becoming very sophisticated in terms of how they approach the entire legal system and judicial system before these projects get down to the local level. And so they had done their homework, in my opinion, and knew exactly what direction they wanted to go and the pieces they needed to put in place and how they wanted to go about initiating their local activity. As governmental bodies, and we get so tied up in day-to-day stuff that maybe we're not looking far enough downstream in terms of what's happening in the whole geographic area, how we interface. And of course, the question with respect to the county has been, what do we do with these zoning districts that we really haven't looked at and we haven't kept up with the changing times and what's going on around us. And we're so involved in this day-to-day activity that we're maybe not looking far enough ahead in terms of, do we reevaluate stuff that had been done 20 or 30 or 40 years ago and see how applicable that is and get in front of the game in terms of recommending changes, be they in our zoning districts or what we're permitting or what the special exceptions are. You know, we should be reserving some time to try to look into the future and say, where are we and how do we measure up ahead of time so that you don't face the same legal issues that you have after the fact, where it becomes much more expensive, it becomes much more time consuming. And I don't know if there's a way to do this with the direction, I guess, of how we run our governmental operations. But I think it definitely is something that we need to pay a little better attention to, is what are those shifting things? You know, the financial people do this extensively before they make commitments, big commitments to billions, tens of billions of dollars to go into certain markets and develop certain products. And there should be a way that we can get a little better handle on how current are we with respect to all the rules and regulations that we put into place and change them before, in anticipation of
and that's a good point, Al, because during bowl season I was watching bowl games, and I see the quarterback for one of the teams goes over and starts talking to this guy, and this guy puts his hands on his head and is talking to him and looking. It's his spiritual advisor. A football team has a spiritual advisor. So, and I'm going, holy cow, that's a new one for me. But I draw that up because what I'm seeing now is maybe the city needs to hire somebody whose whole job is to look at trends, look at what's happening, what some of the problems are in just what you're talking about, especially in Florida with everybody wanting to come to Florida. You know, everybody says that Florida's so crowded. Hey, get in an airplane and drive up or fly over the middle of the state. You'd be surprised how many non-homes there are. It's just that everybody chooses to live on the coast. But maybe if the city, you know, could hire somebody that their whole job is more like forecasting what challenges that the city could meet in the next, just like a comp plan.
Yeah, well, we have a
we
have a 5-year strategic planning process that we involve the citizens in.
So why not do that? Why not do like a 5,
But we're looking
10,
at something that is way beyond
exactly
what the
Think
citizens
outside the
want, another
box.
pickleball court or this is.
Well, I'm going a little bit more than that. I'm going to try and figure out what's I guess you go on the internet and this is what's trending today or this is what's trending now, that you hire somebody in the city who their whole job is to forecast of all kind of possible things that could come up and prepare the city for that. Doesn't mean the city has to take immediate action on a maybe, but they can be aware of a maybe and keep an eye on certain things. One of the things I've started learning.
Comment in the newspaper was that nobody anticipated this, and then when they started to look at what their zoning was, it was written so loosely that.
But that's my whole point.
Yeah.
And I'm agreeing with you that the whole point is that you start looking at things like this, and just like the issue we had tonight, that you look at a way that we can, potentially start to handle and change so that situation doesn't come up and become a legal issue, litigious issue.
I always thought the city should look at, I know every so many years we go over the land development code, right?
Say that.
And the zonings and everything, but just looking at this brought to my attention, what is in there currently in Tomoka Oaks is R2.
Yeah, so let me hit the pause button here. So the proceeding on that matter's done.
No, I'm not talking about that. I'm just using it as an example because my
He'd rather you not.
where I'm getting to is what R2 used to, what R3 used to be, what R1 used to be, what everything was when it was originally written has changed. Our cities have changed, our developers have changed, how many people are coming in, and a way for the city to help maintain itself.
You're just looking for a general review.
So I'm not using
right.
anything in particular. I'm just saying something, this came to my attention.
Yeah, I just wanted to remind everybody, generally speaking, that because the public hearing matter is concluded, we cannot discuss that.
Yes, I'm not talking about that at all. I'm just talking about, I know we go over our codes and everything every so many years, and so that might be something that we could look at, get, like Doug said, the trends, how we want our city to grow from now on. Do we want, that size lot and this, the commercial here or whatever?
We might need zones 4, 5, and 6. I mean,
Exactly, yeah.
Stephen will be happy to do that.
Yeah. I was looking over to see if Stephen was listening.
with definition from your crystal ball.
Yeah. Barry?
Steve, you might want to come sit in the middle so you can hear better.
Barry, what you got?
Well, Angie touched on it, and I was just thinking, what do the people on the planning board of the island and Nantucket do? I mean, do they have something in place to prevent a car wash, a storage facility, extra housing? I don't know if I'm crossing the border here, but I'm concerned about that we do need to look at that at some point, or have some sort of review committee go over it and kind of catch it before it's too late. Because I just feel that it's at some point, and that's why I allude back to what I earlier said about the gopher tortoise. But it just, at some point, we get to become saturated, and there isn't going to be any more room to do anything as far as traffic is concerned, as far as emergency response is concerned. And I don't know, I'm naive in this, but I don't know at some point that it does need to be addressed. And that's all I'm saying. It can't just continue to go in the course that it's going, because at some point, as I said, we're going to have an event, and there's going to be a lot of answers that are going to have to be given as a result of the fact that we're just overcrowded.
Do you have any more?
No, go ahead.
Troy?
So my perspective is a little bit different. First, I want to say thank you, Randy, for guiding us. It's a huge help in coming to the motion. And I was thinking we need to have a definitive position, and I'm glad you helped us out. Secondly, staff, from my perspective, are doing the best job, and I think they're ahead of where we need to be. I know that you guys have reviewed stuff. I know that you don't sit and wait for something to come up and then be reactive to it. I think staff's position on this and review of this and support all along the way was the culmination of us being able to make an easy decision at the end. It was up to the applicant to make it hard for us. They didn't. I think staff protected us. I think, thirdly, the planning board is savvy enough to not be duped and have wool pulled over their eyes. I think, fourth, some of the comments by the community helped our position as well. Again, the applicant did nothing to further drive their application to even be, worth trying to fight for. I mean, I don't know if it is off the record, but it's embarrassing that the attorney came up here and said, I have nothing to do. Let's say. I mean, I was appalled by that. And Mr. Baer said multiple things that I already written down, and that was great. And so, from my perspective, I think we talked a little bit about the PRD. We've talked a little bit about, do we have enough zoning codes? I think we have the vehicle to succeed, and we did today. I think the PRD and them not being able to resort back to R2 and having to make a decision because the PRD expired, there's no automatic reversion. We have those mechanisms and those checks and balances in place. So I think we're doing great. I'm not concerned that we're missing the boat. So excellent job by everyone.
Mike? I was by no means suggesting that the planning staff was not doing that by any means. What I would suggest is that the city give you about 2 or 3 more people to start looking into the future and have that job and help you out so that you guys can do what it is that you do so well. And by that, that is a compliment I'm handing you. But you did want to say something, yes.
I'm not really sure how much interaction you want. So we have an evaluation and appraisal report that's coming up, right? So we're going to look through every element of the comprehensive plan. Pretty exhaustive review. Over the last 10 years, Ormond Beach has been a relatively slow-growing community. There's not that much available land. Now, we've annexed into Plantation Oaks, right? So that's why you're seeing the plats that you're seeing today. We know Ormond Crossings is a growth area. It's been planned since 2004. There are a number of entitlements that are conditioned on the project team doing things, whether it be, a flyover over the railroad. So none of the future development that's being planned has gone without careful scrutiny. May not be perfect, but there's been a lot of analysis. As far as reports, you got to remember that those are design professionals. They are signing and sealing that traffic study, that stormwater report, and other design professionals signing and seal, and then it's reviewed by city staff, it's reviewed by the state, it's reviewed by St. John's. So these aren't, somebody just going and making up a traffic study. So, as we're saying that, you just need to realize that these are design professionals whose livelihood is signing and sealing that, and they have standards, just like planners, just like lawyers, just like, realtors or whatever. So if you want to look at the individual zoning districts, probably not a bad idea. We can start doing that. But the reason that you get certain uses like a car wash or indoor storage is because they're not in the zoning category of uses. So if there's a desire to look at the uses, the city also does a strategic plan. So they're doing more than just planning. They're looking at all the issues with the city. And they do that every, I want to say 2 years, and they bring in a consultant and they go over key issues. So there's a lot of planning, there's a lot of strategic planning, there's a lot of action that are going into the forward motion of the city. So since you let me talk, I just wanted to say that.
Yeah, and Stephen, I wasn't referring to any of that. What I was referring to is what's trending nationally, what you learn from other places and see what they're going through that we haven't yet and none of that. So it is by no means was I trying to put any kind of reflection on our quality, great staff that we have. I'm just trying to get more help so that we can do a lot, get ahead of the curve.
And this year you will see the evaluation and appraisal reports, and I don't mind putting on discussion items to look at the individual zoning districts. It's a great exercise to do.
Okay, thank you.
Besides, you have nothing else to do.
All right, so I think we've pretty much had every say. The only thing that yes, do you have? Oh, no, Mike already did this. I already got that signed for Mike. The only other thing I would like to say is that I'm very appreciative and very grateful for the kindness that has been afforded to me and my family. Adjourned.